We're talking to Rob Wood, who is a tax lawyer, practices in San Francisco, California, and he is a specialist on matters dealing with taxes and also a pioneer in developing the concept of the use of the 468B trust for lawyers. So we have an opportunity to talk with Rob about this very interesting and innovative vehicle. Rob, thank you very much for joining us today.
Thanks for having me, Jan.
Rob, tell us a little bit, to those who aren't familiar with it, what exactly is a so-called 468B trust?
Well, Section 468B is a provision of the Internal Revenue Code. These things have been around for 20 years. They've been used, primarily used in mass litigation cases where there are multiple claimants, and when the defendant wants to get out of the picture, get a release and pay its money, whatever it has to pay, and then very frequently there's an extended process of sorting out claims in the trust for the various victims or claimants.
So as far as the, what would you say to a lawyer who says, well, what benefit is this to me and my client?
Well, as you point out, I'm a tax lawyer first and foremost, and so I tend to think of tax benefits first. I mean, the tax benefits of these things are enormous. That's why they're specifically authorized by the Internal Revenue Code. And tax benefits would be threefold. One, all of the claimants get to decide how they want to receive their money. That's true with the lawyers too. I almost daily I see people who have settled cases and who later wish that they'd taken money in some other way, a structure, for example, for some or all of the payments. And once you have the money, it's of course too late for tax purposes to change it. So lawyers' fees too, many lawyers want a structure. So first and foremost would be that. Second, I think a benefit would be the kind of administration of the thing, which is, again, traditionally you have to decide exactly who's going to get what, and many times you have trouble tracking down claimants, and you can do all this through the trust even after the defendant has paid. The defendant's out of the picture. Third would be, from the defendant's side, is the deduction. The defendant gets a tax deduction up front for all of the payments, even though the payments and the trust may be sorting themselves out for years sometimes. You know, typically it's months, but it can be years. There's actually no duration, no limit from the tax point of view on this. So I mean, it's a great advantage.
What kind of cases or problems or matters has this vehicle been used?
Well, again, the 468B trust was started to address, it started at the insistence of defendants, not plaintiffs. Kind of interesting these days, you know, as in this discussion we're having here, at this conference, these days it's plaintiff lawyers who are trying to take advantage of something that was originally designed for defendant companies to guarantee them an immediate tax deduction, which is again why it's in the tax code, even though the payout process and the administration may take quite some time. So originally, again, going back 20 years, this type of trust, the 468B trust, also called qualified settlement trust, was designed for mass cases with hundreds, thousands typically of claimants. These days, I see half a dozen claimants sometimes even two claimants, sometimes a plaintiff and the plaintiff's lawyer. That's it. I mean, that's all that's necessary is to have claims resolved in litigation, and you can set up one of these trusts very quickly.
How have these trusts been received by the courts?
Received by the courts, the answer is very well. I mean, in fact, they have to be. One of the elements of a 468B or qualified settlement trust is court supervision. So, and I know you and I have done this together. You can go to any court. In fact, the tax code is very liberal, not on a lot of things, but on this it is, allowing any court to establish one of these trusts. So, if you have an ongoing litigation case, for example, and you know, again, I know we've seen this, an ongoing litigation case where the judge is familiar with the case, sort of come to the end of the case and it's time to settle and to start making payments, typically that judge would easily take jurisdiction. You ask the judge, take jurisdiction over this fund, and the judge does. Or, as in cases that you and I worked on recently, you can go to a probate court judge. I mean, probate court judges across the nation are typically used to dealing with trusts. They know what they are. They know there's a trust, a trustee, a beneficiary, and they'll establish it. And once again, some lawyers know a local judge. That's fine too. It's just as long as there is court supervision, it's valid.
What's the best time for a lawyer who's considering doing this? The best time to actually use the trust? At the beginning of the litigation, before the litigation, in the middle of it, at the end when there's a settlement? Do you have any advice to give someone who's contemplating the use of the vehicle?
Well, that's a great question to come from you, because I consider you the pioneer there. Traditionally, and again, I'm going back 20 years, and even going back as little as a year ago, traditionally, the time that people started thinking about these things was literally at the end game. That is, typically only in cases where there's been litigation, and oftentimes only when, therefore, there's a court that has jurisdiction. And then you say, sometimes when you're getting ready to figure out who's going to get what, the process gets a little cumbersome, and somebody thinks, boy, it would be better if we, the defendant may ask for it. Defendant may say, I want to pay now and get out. You sort out of these 10 people or these 100 people or these 1,000 people exactly who gets what. So, traditionally it's in big cases, not necessarily big dollar amounts, but big numbers of claimants, and oftentimes where there's some degree of uncertainty, and usually at the end. These days, and again, I think, I don't think I'm alone in this, you're the one that has pioneered this. These days, there's no legal requirement that there has to be litigation. There's no legal requirement that you need to wait until such time as the litigation or the dispute is about ready to settle to do this. In fact, I now kind of hate it when I get calls from people saying, the money's about to be paid, oh my gosh, if we want to preserve ability to structure fees or structure claims, or we have a dispute among some of the claimants, form the trust tomorrow. I can do that, but I think it's bad business, honestly. So there is no requirement, to circle back to your question. I think the best time is at the beginning, which again, I know you've pioneered. You have lawyers and clients in sort of an aggregation coming together, and there's no rule that the trust needs to resolve itself within 6 months, a year, or even 5 years.
How many practitioners or professionals out there are available to lawyers who may be thinking about doing this? Obviously, you have a very active practice in this field, and I'll ask that you provide your contact information, and we will be providing it on the web as well. But yourself, and who are the other kinds of professionals who a lawyer could go to get advice as to whether a 468B trust would be helpful and how they could go about doing it in their particular situation?
Sure. Well, it's because a trust is something that, as I mentioned, probate court judges, it's something that's traditionally thought of, I guess, in the context of estate planning primarily. It's something that tax lawyers are familiar with. I can't say every tax lawyer is familiar with it, but I think if you do internet searches and look, with any degree of, interest, you'll find plenty of lawyers nationwide. I know. I believe Mark Wallstrom will be interviewing Brian Michaels of ATG Trust Company, which does a lot of this. There are plenty of people around in the tax and trust business that can quickly set up a 468B trust, either as a case resolves or, again, to go back to your earlier question, preferably much, much earlier in the process.
Rob, this has been very, very informative. I appreciate very, very much your taking some moments out from the Mass Torts Made Perfect convention to sit here and discuss with our listeners how a 468B trust, what it is and how it could be used and be useful. Thank you.
Thank you.